Okay, let's talk about Article 13. Article 13 says, Article 13, Clause 1 says, all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of that inconsistency, be void. What this basically means is that, let's say there were some laws in our country which were passed by British before commencement of this constitution, and if there is any law which is against the fundamental rights provided by this constitution, then those laws will be declared as void. Not the entire laws, but only to the extent to which they are inconsistent. Like let's say a law has 4 clauses and the second clause is inconsistent with the fundamental right, then that particular second clause will be declared as void. That's what it means. This is called doctrine of severability. That means that particular section is automatically severed. That's what severed or cut. That's what it means. Clause 2. Clause 2 says that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of that contravention, be void. Same thing again. What this says is that even after the independence, if any government, be it parliament or any state legislative assembly, makes any law which is against the fundamental right, then that particular part of the law will be declared as void. Next, clause 3. Clause 3 says, in this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. B. It says laws in force include laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. Basically what this means is that law means any kind of law. Any law made by state government, central government, or any ordinance that was passed by governor or presidents, or any kind of notification, regulation, anything like anything that is passed by the government cannot violate the fundamental rights. That's what this basically means. Clause 4. Clause 4 says nothing in this article shall apply to any amendment of this constitution made under Article 368. What this basically means is that Article 368 talks about amendments to constitution, how amendments can be made to constitution, and what basically this means is that any constitution can be made so that it can any amendment can be made so that it can restrict the fundamental rights. That's what it means. And this thing is a little bit controversial. We'll come to that in later videos.